I want to introduce Susan Schneider. She's my research assistant, thank God. And she's a JD candidate here, graduating this year. And she's also receiving her Master's of Education from SU simultaneously. And we talked about this project, early in the fall, about trying to do something on this subject of resegregation, is one way to put it, of the school system. And she's come up with some great materials. I know I lambasted you with a lot of stuff to read, but it's a nice collection of material. And I'm just going to leave it to her. The setting right here, let's just imagine ourselves to be a small boutique civil rights firm. That's what we do. We do civil rights litigation. Or you can consider us a funded, not-for-profit institute that does litigation in the area of civil rights. Either way, that's who we are, and we're here because a member of our team came up with this issue and said, let's canvass it to see if there's anything we can do. And so we're brainstorming right now, and we're getting a little bit of an overview.
Hi, everybody. Okay. At the end of this, I want you guys to be presenting an argument to me and to Professor Kelder. You're going to have 4 to 5 minutes to do this presentation, okay? And I'm going to give you a lot of time to work on it because there's a lot of material. So I'm going to throw a lot of information at you, a lot of cases at you. That's why I wanted to make sure you guys had the slides on paper so you weren't like furiously trying to write stuff down, okay? So I'm going to attempt to use this. I need a clicker, so I guess I'm going to be back here a bit. So we're talking about constitutional rights in education, which is kind of a weird subset, a lot of people think, because education is mostly state-based. Question I want you guys thinking about is, can de jure segregation decisions be applied to today's de facto segregation? Okay, I know you guys went through the difference between de jure and de facto. Okay, so you're really going to have to put that into your head as to how you can take something that has been applied by laws and now is actually not applied by laws but just is implied in fact. Okay, that's basically the big question that you're going to be asking yourselves in your group. This is where we're going. We've got 3 major subsets to go through, and I'm going to try to get through them as fast as I can, and hopefully not be boring as well. So what can we pull from Brown v. Board? Because that's our basic case that we have for this. Okay, we want to look at what was argued in Brown. Okay, so the plaintiff's side, with Thurgood Marshall, okay, contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the laws. That was their argument. Okay, this is what backed it up. Okay. Competent, uncontradicted expert testimony sufficient to enable this court to make a critical analysis of the constitutionality of statutes requiring racial segregation in elementary and high schools. They also said that the case of Brown is whether a state which undertakes to provide public education on elementary and high school levels for its residents can satisfy the requirements of the Equal Protection Clause of the 14th Amendment if it compels the segregation of pupils from all others. Okay, so that word compel, that's a very big word that you're going to want to watch out for. Also in their brief, they talked about expert witnesses that they put on the stand, that they were going to put on the stand. They basically would show that compulsory racial segregation of pupils was harmful to the segregated students on elementary and high school levels and deprive them of educational opportunities and advantages equal to those enjoyed by white students. Now this was accepted by the Supreme Court in higher ed. It had not been accepted in the lower grades. So you had 2 cases, McLaurin and Sweat, I'm not sure. And that basically said that those educational opportunities that they were talking about only apply to graduate and professional schools. The Sweat case was actually a law school. And then they expressly reserved the decision on the question of whether Plessy v. Ferguson should be held inapplicable to public education. So they said, we're going to decide this for higher ed, we're going to decide this for law schools, but we're not going to decide it for K through 12. We're going to say that segregation, unequal schools, it's still okay. So then we go to the defendant's argument. Okay, so this is the school board's argument. Anybody remember which school board this was? What state it came out of?
Kansas.
Thank you, Topeka, Kansas. Okay, so according to the decision, one of their main arguments was basically that the schools were equal. That even though they were separate, they were equal in every respect. And they called these the tangible factors. Okay, and that's the buildings, curricula, qualifications, and salaries of the teachers. Okay. In their brief, they said that there was a total absence of an allegation of inequality in the schools. That was one of their main arguments. And basically they said that if they're not going to allege it, we're going to assume that these schools are equal. So therefore, there is no issue. There's no claim to be had here. So that was one of the defendant's main arguments. Okay, now what was actually decided, and this we kind of know, but you really have to pay attention to the language to make the argument that we're trying to make here. Okay? Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal education opportunities? We believe that it does. Okay, that's one of the most quoted things out of Brown. Okay, to separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Kind of impressive coming from the Supreme Court. Okay, and then of course it overturns Plessy v. Ferguson in K through 12. Separate but equal has no place in public education. Okay? Separate educational facilities are inherently unequal. We know this. Okay? But then they go on to say, therefore we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of. Okay? That is what kind of segregation that they're talking about? De jure or de facto? De jure. That's the de jure complaint, right? So does that mean that this decision does not apply to de facto? That's one of the arguments we have to consider. Okay. And then regarding the constitutionality of segregation in public education, we have now announced that such segregation is a denial of the equal protection of the laws. Now the segregation based on race, are they talking about any segregation based on race, or are they talking about de jure segregation? Not clear. Okay, and how should we apply these specific terms? We already went through these. Solely on the basis of race, solely because of their race, separate but equal has no place, segregation complained of, and such segregation. What kind of segregation are they talking about? Now, the re-argument that they had, I don't know how many of you actually went into the history of Brown, but it was argued in one year, and then it was re-argued the following year, because there was a death in the Supreme Court, major issue, so then they had to re-argue certain things. This part of the re-argument, as they call it, was trying to figure out what Congress meant when they actually made the amendment, the 14th Amendment. And they said it was inconclusive. The most avid proponents of the post-war amendments undoubtedly intended to remove all legal distinctions among all persons born and naturalized in the United States. However, the opponents were antagonistic to both the letter and the spirit of the amendments and wished them to have the most limited effect. And what others in Congress and the state legislatures had in mind cannot be determined. Supreme Court looked into this, researched it, and they said it was inconclusive. Okay, so that's Brown. I'm actually right on time. Yes. It's a lot of information to get through. Okay, so next, we're going to head to what's going on now. segregation in today's public schools. We have something that has kind of been termed a resegregation case, which is the Dowell decision in 1991. Basically what this did was it allowed schools to, it allowed them to resegregate, basically. It said, okay, if you have achieved unitary status, which you guys read about, then we're not going to subject you to our oversight any longer. So all of these districts that were segregating based on law and now had to deal with the oversight of the Supreme Court no longer had to deal with it. The court said, you're on your own, you've done a good job, props to you. So you see after 1991, and I'm going to actually exit out of this, after 1991, there is a huge jump. Okay, so this is the best list I could find. You don't have to know this completely, but this is basically when the orders were lifted. So all of the districts here were told that they were segregating de jure. And then the Supreme, or not the Supreme Court, but the courts involved, the district courts and whatnot, said, you know what, if there's a date here, year lifted, they said, you're doing a good job, we're not going to subject you to oversight any longer, okay? So you see, this starts in 1967, okay? That's what, 13 years after the Brown decision, okay? And then you go through, you have the 70s, 80s, now we get into the 90s. Here's 91. It's not going to let me highlight. But here's 91. This is when that court decision was made, the Dowell decision. Now look at all of the districts that were released from oversight through the 90s, into the 2000s, continuing. This is why this was not included on your spreadsheet. 2010s start here, okay? It's a lot of courts that decided, you know what, after 1991, we're okay now. We no longer have to do oversight, okay? The counties that are still open, which means they are still under oversight by the courts, there's still quite a few of them. Courts are saying you're still segregating. You're still under oversight. What you're doing is still not okay. Okay? So it's still there. It's still a big issue. All right. So back to Prezi. Okay, numbers and stats. I'm gonna kind of breeze through these because I don't know about you, but when I see numbers and stats, my eyes start to roll in the back of my head. You have some stats in the stuff that I gave you to look at. If you, during your group consultation, want any of these stats, you want to look at them again, write down which one it was, the number of them, or whether it was the pie chart or whatever it was. Write down something that says, I want to look at this again. I'll pull it up for you, no problem. So don't worry about getting down all the information, okay? So the first one, map shows the percentage of black students attending schools in which 90% or more of the students are minorities. These are intensely segregated schools, okay? As you can see, the dark blue states, of which New York is included, that means that much of the student population that's black is going to highly segregated schools. 90% of their school population is a minority, okay? This bar graph, oh, you do see my mouse, okay, represents a number of black students attending school with a given percentage of minority students. That 90% of intensely segregated schools, that's a pretty large bar, okay? Public school enrollment by region. These are just numbers, basically, okay? So you can kind of see, if you break it up by regions of the U.S., where white, black, Asian, Latino, and AI is American Indian is what they term it, and now mixed races, as they term them on census polls. Okay, you can see where everything is concentrated. First grade public school enrollment by region. This is one of my favorite graphs. The Southwest, generally termed as the West, okay? Latino population. Now this was 2009, 2010, so 4 or 5 years ago. They estimate the numbers of prisons they have to build by this number right here. The number of Latinos that are entering first grade. That's how they assess their prison population. Just a side note. Public school enrollment. This is nationally. Before we had the graph that showed them separated by regions, this is nationally. And there you have the comparison in a nice handy-dandy pie chart, which is always good to have something visual. So you can see the difference. And that's just in 40 years. Okay, these bigger graphs. Public school enrollment in 2009-2010 for the top 25 highest enrolling core-based statistical areas. So city centers. So as you can see, top 5. First one on there, New York, Newark, Edison. So you've got tri-state area, okay? Breaks it all down by percentages and total students. Number of students in schools of different levels of segregation by race, okay? These I always find really interesting. This one is actually the numbers. We have one coming up that's percentages. So you have your 50 to 100% minority school. So those are your half and half schools. Not too shabby, okay? Then you start getting up to intensely segregated, 90 to 100% minority schools. Those are your numbers. And comparison from the 1990s to a couple years ago. And then the 99 to 100% minority schools, okay? Now, this is when you hear people saying that we've gone back to the numbers of predating 1963 levels. Usually this is kind of what they're talking about. They're talking about numbers, not percentages. And you know that numbers can be massaged however you really want them to be. So you can see that these numbers are going up, but that's also because populations have gone up. So when you see the percentages, you're going to see the percentages are a little bit different than what this chart might lead you to believe. But you can see with those numbers, it's still a lot of kids. Okay, now you have percentage of racial group and minority schools. Okay, so there are your percentages. As you can see, black population in intensely segregated schools, 64%, late 60s, down to 38%. This is great news. Latino populations, 23% in the late 1960s, up to 43%. They've almost doubled. So that's where our segregation issues are really coming into play. It's really the Latinos that are seeing this now much more than the black population. Percentage of racial group in minority schools, okay, again, just by region. So these are your percentages instead of your populations. Correlation between poor students and ... Okay, so now we're getting into what they call double segregation. Not only by race, but now also by class, by wealth, okay? Numbers, these are kind of interesting. I mean, they have specific equations that they use, that they come up with to decide the correlations that they're looking for. And I'm telling you, unless you're a stats major, stats person, those things are like Greek. Well, that's because they use Greek letters probably, but they're kind of difficult to look at and understand. However, these tables are really, really nice to look at. Okay, correlation between poor students and white students, less than 1. Less than 0.1 is what I should say. Black students, you're at about 0.5. Latino students, you're at about 0.7. Okay, there is statistical data backing this up. It goes up even higher when you consider black or Latino, up to 0.8. Student exposure rates to poor students. So exposure rates, again, it's another equation that's pretty massive and lengthy that I wasn't going to put out to you guys. But what they're looking at is how much you're exposed to these people. So if you went to a well-to-do school, high school, how many poor people were in your school? And how do they define poor people? It's the people that are eligible for free and reduced lunches. So it's a little bit higher than the poverty level. If you looked at any of those and the stats that I gave you guys, they have the poverty level, but then you can also compare that to the free and reduced priced lunches, breakfasts and lunches. Okay? That's how they define poor in the school system. Student exposure rates, again, to poor students in public schools for the top 25 highest enrolling city areas. Okay? Same chart we were looking at before, different percentages. So these are your exposure rates. Most segregated states for black students. These charts are always interesting, okay? So these are your states that are most segregated. 99 to 100% minority schools. Illinois, Chicago, Michigan. What's the big city in Michigan that you're going to see that in? Detroit. New Jersey. Anybody been to Camden? I wandered in accidentally. Try to get out just as quickly, right? Tennessee, New York, Alabama, Pennsylvania. Okay, so these are 99 to 100%. That's where they see those schools most often. Then you have the intensely segregated schools over here in 90 to 100%. New York tops it out. Oh, I should point out one other thing. The note. Usually I don't pay attention to notes, but note DC. 99.1%, 50 to 100%. 90.4 compared to New York, 63%. 80.4 compared to Illinois. Those are some pretty stacked numbers in DC. DC usually doesn't get figured in because it's not considered a state. It's a district in itself. You have a question?
But wouldn't that be based off the makeup of the population?
Absolutely. That's one of the things. That's one of the things that we're going to consider in one of the cases.
Okay.
Is if you've got a population within a district or a city that is intensely black or Hispanic, whatever, how does that compute when you've got schools as well? Do you force desegregation across county lines, across state lines, across district lines? And there are cases that deal with that. That's a huge question that courts have had to deal with. Glad you brought it up. Okay, colorful graphs. Percentage of black students in intensely segregated minority schools by region. These are your 90 to 100%. You can see they were all, except for Northeast, thank you New York, we are fabulous. They were all going down after 1968. Then you hit the 1991 court case, and you see what's starting to happen. This is the trend that people are worried about. This is the resegregation trend that people are starting to talk about. Midwest, starting to come back down, hoping that that trend continues in the Midwest. But those are some highly segregated schools in there. That's your Chicago and your Detroit area. South region, which most people are most interested in, again, black students had more equal schools going up until that 1991 case starts to go back down. You're seeing the resegregation trend here. So are we at 1963 levels? No, we're definitely not. But we're getting on a trend to get there. Now, most segregated states for Latino students. No surprise, New Mexico, California, Hawaii, Texas, topping out over here. New York, I was actually kind of surprised to see New York up at the top here. Then we've got Texas and California, okay? Texas and California are big states for this. Okay, and this one I like because it's so simple, okay? These are your intensely segregated schools, 90 to 100%. Black population, 1960s, 64, goes down to 32. 1991, going back up just by 2%, but 10 years later, up 4%. okay? Latinos, 23 to 32 to 34 to 42, climbing. I like the simplicity of that one. Okay. For those of you that might, are there any local people? Okay, a couple. Okay. This is a Syracuse area. This is what we're talking about metropolitan issues, okay? Can you find Syracuse on the bar graph? It's not hard to pick out, okay? By population, in the schools, black students. Here's Syracuse City School. All of the surrounding schools are down here. Okay, so these are charts that I made from the data that I gave you guys in the spreadsheet. Okay, white students, here's Syracuse. Okay, here's your poverty level compared to your free and reduced lunch. Okay, again, Syracuse, easy to find, almost doubling all of the surrounding districts.
Suze,
Yeah.
what is that? Does that mean 80% of the students are on a free and reduced?
77.7%.
All right.
Yep. Okay, and then these are grade distributions. Testing. We love testing, right? 4th grade average between ELA and math. Now these were 2011 stats, okay? Here's Syracuse. School is not doing well. 8th grade average. Syracuse goes even lower. High school English. Okay, I separated the high school out. That's nice. Okay, high school English. Again, you're seeing the same trend. High school math. Okay? They're seeing unequal schools. Okay, so that's the data. Now all the court cases. Okay, so this is all U.S. Constitution unless it's otherwise noted. These are cases that went up to the Supreme Court. Okay, so this is the law for every single school district out there. Okay, obviously we start with Brown v. Board. Separate but equal has no place. Separate educational facilities are inherently unequal. Plaintiffs are deprived of the equal protection of laws guaranteed by the 14th Amendment. Yes?
Just before we get into this, regarding the data, is there a comparative data set for college graduates with respect to the demographics of Black and Latino children after 1960? I mean, obviously of that initial period post-68, and then now more recent data, you don't have college graduates yet. So.
Yep, I have a lot of that data, but I didn't.
What's your general impression?
I didn't include it in this because I wanted to stay in K through 12, but they're seeing the same trend. So they're seeing less acceptance at the college level of Black and Hispanic students, and that's a lot to do with the affirmative action cases that are starting to come across at college level that basically are saying we can't deal with race at all, so there is no affirmative action anymore in college acceptance. Graduation rates, same type of thing. You're seeing a lot of the kids that go to these highly segregated schools, if they go to a community, if they go to college, it's usually community college, and the vast majority of them do not finish past their first year. It's very unusual to see. There are schools, there are inner city schools, there are metropolitan schools that are intensely segregated that mar that wonderful trend, but they're few and far between. So it does continue into college. Good question. Okay, so Brown v. Board decided in 1954. Companion case was Bowling v. Sharp. Okay, and that dealt with the due process clause. I'm going to get my list so that I make sure I cover everything I want to cover here. Bowling v. Sharp was also unanimous. And basically the idea here, it was a DC case that went up to the Supreme Court. And what had happened is there was a dual school system, as they call it, and the white school was opening up a brand new facility, and they weren't intending to invite blacks to enter whatsoever. And the Supreme Court basically said, you can't do that. Because, I mean, it went back and forth between the courts, and they were trying to say all the time that they were constructing this building, that they should construct it over by the black school. By the time it got up to the Supreme Court, the construction was done. They're like, well, that's a moot point because the building's already built. So now we're going to say that they have to accept black students. Okay, so that was Bowling v. Sharp, and it was a due process clause claim. Brown 2, we know this one because of the last phrase, with all deliberate speed. But what I want to really concentrate on here is their thoughts on Brown. And they said that Brown declared the fundamental principle that racial discrimination in public education is unconstitutional. All provisions of federal, state, or local law requiring or permitting such discrimination must yield to this principle. So it's not just law that says, okay, you must segregate or we allow segregation. It's permitting. Okay, so it's not that the law is necessarily compelling this discrimination, but that it permits it. It's a big thing that Brown 2 states. It also says that school authorities have the primary responsibility for elucidating, assessing, and solving these problems. So it says who has the responsibility to make sure that this doesn't happen. And then it gives the courts oversight for those districts that have been declared to segregate. So it says courts will have to consider whether the action of the school authorities constitutes good faith implementation of the governing constitutional principles. So they're saying we're leaving it up to the districts, but we're going to do the oversight. And that's that huge long list that we saw when we were talking about Dowell in 91. Okay? Green. Okay, this is your free choice case. What do I mean by free choice? There are 3 general free choice options. Who can name one of the 3? It's not difficult. Shout it out. If you have free choice. Magnet schools. That's a big one. There's 2 other big ones. Charters. Okay. You guys studied the 3rd one. Florida was huge on it for a very long time. They're still trying to get it through. Vouchers. Okay. Florida is the state that really likes to try and push vouchers. Okay. So those are your 3 free choice options. Okay. What Green did is it said that freedom of choice is not an end in itself. It can be used as a method, but just because you say that your school, your district is going to allow free choice through one of those 3 methods, that's not the end of your segregation problem. You have to make sure that that method actually helps the situation. Okay? So it says school boards such as the respondent, which is the Greene County School Board, then operating state-compelled dual systems, black-white systems, were nevertheless clearly charged with the affirmative duty. They have an affirmative duty to take whatever steps might be necessary to convert a unitary system in which racial discrimination would be eliminated root and branch. Okay? Districts have an affirmative duty. Then we get down to Swan. This is 1971. Okay, so Swan was another school construction case. And basically what they said is that the responsibility of local authorities and district courts was to see that future school construction and abandonment, so closing of schools, are not used and do not serve to perpetuate or re-establish the dual system. So you can't create another dual system or perpetuate your dual system by closing schools, specific schools. So, okay, we're going to close all these black schools so that they have to integrate with white schools, but then there's not enough room. So then we have to either add on to the school or build a new school. And what do you know? Resegregation. Okay? They're saying you can't do that. Okay? Granted cert in this case to review important issues as to the duties of school authorities and the scope of powers of the federal courts. Okay? Where it is possible to identify a white school or a Negro school simply by reference to the racial composition of the teachers and the staff, the quality of the school buildings and equipment, or the organization of sports activities, a prima facie case of violation of substantive constitutional rights under the Equal Protection Clause is shown. You can walk into a school and say, yep, this is a black school. Walk into another school in that district and say, yep, this is a white school. You have your claim. When a system has been dual in these respects, the first remedial responsibility of the school authorities is to eliminate invidious racial distinctions. And they're saying that you can do that with transportation, supporting personnel, and extracurricular activities, and sometimes that's all it takes. However, faculty assignment, school teacher equity is the buzzword now. And new school construction deserves more, okay? So then they're saying that for student assignment, there are 4 problem areas. Racial balances or racial quotas, one-race schools, remedial altering of attendance zones, and transportation of students. Those are your 4 main issues when you're dealing with desegregating schools. Okay. Now, this is the part that I really hate about this court case. It does not follow that communities served by such systems will remain demographically stable. For in a growing mobile society, few will do so. Neither school authorities nor district courts are constitutionally required to make year-by-year adjustments of the racial composition of student bodies once the affirmative duty to desegregate has been accomplished and racial discrimination through official action is eliminated from the system. So as soon as you're declared that you don't need oversight, guess what? We don't really have to look at it again. We don't have to look at it year by year. You don't have to look at it year by year. Because you know what? It's going to change, and we accept that. Okay. Next, I wanted to go on to 2 cases that never made it to the Supreme Court, because I want you guys to really be thinking about the population that we're talking about when we talk about resegregation of schools. We've already shown you through the stats and the numbers that segregation as far as black students are concerned is generally going down. And if you look at any of the numbers for the South region, it has gone down tremendously. However, segregation of students that are Latinos has gone up. And that's the trend that we are seeing throughout the nation, is that is your most segregated group. Another segregated group that I really want you guys to consider, students with disabilities. And this doesn't come up a lot, okay? So Park and Mills, I had you guys read through Mills, at least some of it, okay? Mills I wanted you guys to read because I wanted you to see that it was a DC case. All of the kids that were involved were all black students. And they could have brought it under a 14th Amendment claim for segregation of black students. Instead, they decided to bring it as students with disabilities. This showed your trend from 1954 to 1972 of how schools were getting around the segregation issue. Well, our black students have to go somewhere, but we don't want them in regular schools with our white kids. We don't want this. So where do they put them? They wind up putting them in special ed programs. And we're still seeing this today, okay? So you have a huge proportion of black students going into special ed programs, much more so than white populations. And there are lots and lots of reasons for this. Like we had pointed out before, it can be population. So the schools that see it in inner city, all of the health concerns that you see with inner city and public housing and all that kind of stuff, that all contributes. But the correlation just simply between, okay, they're black, so they must go into special ed, or they have a higher propensity to go, it doesn't wash. So you're seeing these kids being rooted out of white schools because they don't want them to desegregate, basically, okay? Now the problem here is that once you're labeled special ed, up until the 1970s, guess what? You have no right to enter a school building. You have no right to education. None. Public school system does not have to educate you. Park and Mills changed that. It allowed access to these kids. So now they could be in the school building. We're still seeing high levels of segregation as far as in classes, in programs. So you have a school, yeah, we've got our population of 10 to 14%, sometimes as high as 16%. Syracuse City Schools, I think, has a 20% of students with disability. How many of them are in your classrooms? Think about your high school class. You should have seen roughly about 16 to 17% of your classmates as classmates with disabilities, whether they were invisible disabilities or physical disabilities. You think you saw that? I know in my high school I didn't. And I've done research on my area, which was Broome County, top of the list on my stats, okay? And it's just, it's not there. We had a separate school. So I want you guys to consider this, okay? Not only do we have discrimination on race and on poverty level, but now also on ability level. And this is at the forefront of some people's mindset when they're talking about civil rights, students with disabilities, okay? In response to Park and Mills, direct response, Congress created different acts. The EAHCA, which has turned into the IDEA, which some of you might have heard about. And it also helped to create Section 504 of the Rehabilitation Act in 1973. They actually took language from these court cases and put them directly into the acts, word for word. Unfortunately, what this might do, and this is something that is my thought, is instead of allowing these people 14th Amendment rights, they're saying, we're going to give you an act that kind of sort of maybe gives you rights that kind of sort of maybe mirror the 14th Amendment, but we're not going to necessarily say that you're part of the all citizens. So that's just something to think about. That's why I had you guys read Mills. So I wanted you to see that that was an issue. And they could have brought it under segregation of black students, but they decided not to. Then we have Rodriguez. I think you guys read this. 1973. This is the court case that says, guess what? Education is not a fundamental right under the U.S. Constitution. It's not even a right under the U.S. Constitution. We find neither the suspect classification nor the fundamental interest analysis persuasive. That's it, right? Not completely. Okay? I think we'll come back to this later. But the court says in Rodriguez, I don't know why that keeps coming up. Court today does not pick out particular human activities, characterize them as fundamental, and give them added protection. To the contrary, the court simply recognizes it, as it must, an established constitutional right and gives to that right no less protection than the Constitution itself demands. Now, in this case, which is really, really, really long, it compares education to housing and to a couple other things. And it says, we're not going to say that you have any type of right to an education, even though we've already admitted in Brown that it's something that everybody needs, kind of like the healthcare debate. We're not going to say it's a right. Lau was in 1974, the very next year. And this, to get some background on it, this was the non-English speaking Chinese students case, if you want to think about it that way. Basically what they said is that Chinese students that were in California had no English ability. They couldn't understand a word that was being said to them in the classroom. The U.S. Constitution said that's not okay. The school has to make sure that they have some way to interpret, or they have to make sure that they are giving English lessons. This is the whole idea of your ELL, English language learners. Because it's unequal educational opportunities. Okay? Those opportunities aren't found for every single person. So once we get into Rowley, which I had you guys kind of look at a little bit, you'll see that opportunity, that's a really, really big buzzword. Okay? There is no equality of treatment merely by providing students with the same facilities, textbooks, teachers, and curriculum. For students who do not understand English are effectively foreclosed from any meaningful education. Milliken, also in 1974. Told you we were going to go through a lot of cases. This is your districting case, okay? So basically what this case said was you can't go outside of district lines to help desegregate your district if the other districts outside have not violated the Constitution. So, actual desegregation raises the fundamental question as to the circumstances in which a federal court may order desegregation relief that embraces more than a single school district. Before the boundaries of separate and autonomous school districts may be set aside by consolidating the separate units for remedial purposes or by imposing a cross-district remedy, it must first be shown that there has been a constitutional violation within one district that produces a significant segregative effect in another district. You must show causation. The record before us, voluminous as it is, contains evidence of de jure segregated conditions only in the Detroit schools. Indeed, that was the theory on which the litigation was initially based. That was their argument. With no showing of significant violation by the 53 outlying school districts and no evidence of any inter-district violation or effect, the court went beyond the original theory of the case as framed by the pleadings and mandated a metropolitan area remedy. To approve the remedy ordered by the court would impose on the outlying districts, not shown to have committed any constitutional violation, a wholly impermissible remedy based on a standard not hinted at in Brown 1 or 2 or any holding of this court. So that was the question that was posed earlier, okay? Can't go outside of your district limits unless you can show a causation. Rowley was in 1982, so almost 10 years later. Okay, so this actually talks a little bit more about the EAHCA, which is now the Individuals with Disabilities Act, okay? It's saying that the act was designed to fill the need identified in the House report, which was equal protection. That is to provide a basic floor of opportunity consistent with equal protection. Neither the act nor its history persuasively demonstrates that Congress thought that equal protection required anything more than equal access. So, if you compare this to Lao, Chinese students, they had access to the school, they had books, they had teachers, yet their educational opportunity was not satisfactory. However, access is all that kids with disabilities need. That's what the Supreme Court is saying here. Congress's desire to provide specialized educational services, even in furtherance of equality, cannot be read as imposing any particular substantive educational standard upon the states. Plyler v. Doe, 1982, same year. Okay. This was basically a case, we'll speed through this one. This basically said that if you are an illegal alien, you have the right to an education within our borders. Okay? You guys have this? Okay. Denial must be justified by showing that it furthers substantial state interest. Okay? Because education is not a fundamental right, there just has to be some state interest. Okay? And we'll go back to that finding in a little bit. But that's the essence of Plyler, was that if you're an illegal alien, you still have a right to education, even though you're here illegally. We're almost done, I promise. We're up to the 90s. Dowell, this is what we already talked about. The test that they proposed in Dowell to continue desegregation efforts, the board would be entitled to such relief only upon nothing less than a clear showing of grievous wrong evoked by a new and unforeseen conditions. Supreme Court said no, rejected that idea. Parents involved. You guys are familiar with this case. 2007. Yes? Yes? No? Yes? Okay, a couple of nods. I promise I'm almost done. Okay. School districts in these cases voluntarily adopted student assignment plans that rely upon race to determine which public schools certain children may attend. So basically what they had is they had a bunch of schools within their district. This was in Washington State, Seattle, Jefferson County. And they basically said, well, if it's a tie between two students and we're seeing that we need another black student or another Latino student to make the racial quotas or balance, if you want to use those terms, then that person will get a leg up from someone else. It's kind of like affirmative action. However, racial balancing is not transformed from a patently unconstitutional to a compelling state interest simply by relabeling it racial diversity. While school districts use various verbal formulations to describe the interests they seek to promote, racial diversity, avoidance of racial isolation, racial integration, they offer no definition of the interest that suggests it differs from racial balance. 14th Amendment prevents states from according differential treatment to American children on the basis of their color or race. And the most famous quote you'll find with people that are involved in civil rights activism: the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Basically, that's saying we need to be colorblind, not color conscious. There is an issue with that. We'll get to that in a few seconds. Last case. Oh my goodness, last case. Horn in 2009, New Mexico. This is still an ongoing thing. Yes, this made it to the Supreme Court, but I'm telling you, Horn is still down in New Mexico making waves. He is doing some really interesting things down there. Basically, what this did is it took kids that were ELL, kids in New Mexico, this was in Tucson, and basically said, you know what? We're going to put you guys in one of two programs. I think I have it listed here. Maybe not. There was there it is, a structured English immersion program, and then there was a compensatory instruction fund. So you had an immersion fund, which basically meant money so that kids could go into classrooms and be immersed in the English language, or compensatory instruction, which meant you got to go to a class that was, at best, remedial, but in your own language, so that you could start to learn English while you were learning core subjects. This was segregating via class and via program. They also have a program down there, I'll say to you as an aside, a Hispanic Studies program. They also have a Black Studies program, and they have a few others. Those are a little bit different. They do curricula, so instead of doing a regular government course, you're going to do something in Latina government within that area. So that's an interesting take on what they're trying to do in New Mexico. That's the schools. This was something completely different. This was saying either you're not going to get any help learning the English language, and that was your immersion class, or you're going to be pushed into a remedial class if you can't speak our language yet. So it denied them regular curricula. However, the Supreme Court remanded this case back down to the original court, saying that overcoming language barriers is a vitally important issue. And if petitioners are ultimately granted relief from the judgment, it will be because they have shown that the school district is doing exactly what the specific statute requires, which is taking appropriate action to teach English to students who grew up speaking another language. They're saying that this could be deemed appropriate. If your local court says it's okay, then we're going to allow segregation within the school. So, we're almost done, and then we're going to split into groups. One last part of this. What rights are involved? Obviously, we know due process and equal protection. So we're going to go back to Brown for a second. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. Then in 1973, it is this question, whether education is a fundamental right in the sense that it is among the rights and liberties protected by the Constitution, which has so consumed the attention of courts and commentators in recent years. We know what the Rodriguez court said, right? Before we get into that, just want to remind you of this wonderful chart that I'm sure every single person has in their notebooks. Rational basis review, intermediate, and strict scrutiny, and where this falls. Supreme Court says, you're not dealing with suspect classifications unless it's very specifically race-related. Okay, then it's a suspect classification. But it's not a fundamental right, which would put it into rational basis review. Keep this in mind, because I think there's a very strong argument that this could fall into strict scrutiny instead of rational basis. But that's my argument. I want to see what you guys come up with. Arguments to make education a constitutional right. Specifically, they insist that education is itself a fundamental personal right because it is essential to the effective exercise of First Amendment freedoms and to intelligent utilization of the right to vote. In asserting a nexus between speech and education, they urge that the right to speak is meaningless unless the speaker is capable of articulating his thoughts intelligently and persuasively. Similar line of reasoning is pursued with respect to the right to vote. Exercise of the franchise, it is contended, cannot be divorced from the educational foundation of the voter. The electoral process, if reality is to conform to the democratic ideal, depends on an informed electorate. A voter cannot cast his ballot intelligently unless his reading skills and thought processes have been adequately developed. Supreme Court's response. I think that their response really mirrors the argument that was made. I personally don't think that this was the correct way to make the argument. I want to see what you guys come up with, but this is what the Supreme Court's response was to those arguments made in Rodriguez. We need not dispute any of these propositions. The court has long afforded zealous protection against unjustifiable governmental interference with the individual's right to speak and vote. Yet we have never presumed to possess either the ability or the authority to guarantee the citizenry the most effective speech or the most informed electoral choice. The key to discovering whether education is fundamental is not to be found in comparisons of the relative societal significance of education as opposed to subsistence or housing. Nor is it to be found by weighing whether education is as important as the right to travel. Rather, the answer lies in assessing whether there is a right to education explicitly or implicitly guaranteed by the Constitution. We have carefully considered each of the arguments supportive of the district court's finding that education is a fundamental right or liberty, and have found those arguments unpersuasive. I would agree, actually. I don't think the arguments were persuasive. Education, of course, is not among the rights afforded explicit protection under our federal Constitution, nor do we find any basis for saying it is implicitly so protected. We need not rest our decision, however, solely on the inappropriateness of the strict scrutiny test. A century of Supreme Court adjudication under the Equal Protection Clause affirmatively supports the application of the traditional standard of review, which requires only that the state's system be shown to bear some rational relationship to legitimate state purposes. But in Bowling in 1954, segregation in public education is not reasonably related to any proper government objective. I don't know about you, but those seem to completely contradict each other. Getting to the very, very recent cases in California and the ongoing case in New York that are obviously not Supreme Court cases. These are regular district court cases. I really want to get into, this is the very end, what the state constitutions say, okay? Because I had you guys read Vergara, the, now I guess it's the official opinion of the court. And according to most state constitutions, not only is education a right, but it's a fundamental right. As noted in Vergara, it's a fundamental interest. It is well settled that the California Constitution makes public education uniquely a fundamental concern of state and prohibits denying basic educational equality to the students of particular districts. State itself bears the ultimate authority and responsibility to ensure that its district-based system of common schools provides basic equality of educational opportunity. That was in 1992, California level. What I'm asking is, can this line of reasoning be brought to the federal level? Can you use what we saw in Brown? Can you use what we saw in Brown 2? Can you use this wonderful statement that I love from Bowling that says, it's not a government interest. Doesn't matter what argument you make. Any type of segregation is not a government interest. Period. So that's my question to you guys. Can you take these arguments and can you make a U.S. Constitution 14th Amendment claim that what's going on now, the de facto segregation that is going on now, that a lot of it that still has basis from de jure segregation, can you make the argument that education should be a right, possibly a fundamental right, that would deal with strict scrutiny, that would clearly take the Brown decision from a black-white dichotomy into what we're dealing with now, which is black, Hispanic, students with disabilities, along with poverty? Can you make that argument? I think the argument is there to be made. And that's what I'm challenging you guys to do today. Like I said, it's a lot of information. There are lots of stats that you guys have seen, that you have access to, that I can bring back up. I want you to take the court cases, take the numbers, take the stats. I want you to crunch them. I want you to brainstorm. And I want you to come up with what your best argument would be. I want you to sell me on what your best argument is. And if your best argument is, you know what, maybe we shouldn't take this to litigation, maybe we should take it somewhere else, you got to back that up, especially since this is a con law class. I'm expecting constitutional law arguments. I'm expecting 14th Amendment arguments.
I just wanted to underscore the backup. I know it's a constitutional law class, but not every problem gets solved through litigation under the Constitution. What I want you to consider, if you don't think that there is a constitutional argument to be made here, I want you to think of the options. What's a non-litigational option here for solving this problem? Magnet schools, charter schools with strict, diversity requirements imposed upon them. Vouchers, even to sectarian schools. We've set this up, right? Political solution could run headlong into, oh my God, do we have an establishment clause concern? Oh my goodness, is this illegal affirmative action, violative of equal protection itself? We'll have defenses. That's where the Zellman case and the Parrots case come into play. But I want you to think about that too. That's a part of this enterprise. We are a litigation institute, but we know how to organize and get the groundswell moving with, political officials. So go ahead. How much more time are you going to give them?
This is what we're going to do, which is actually, we're right on time. I'm so excited. This is one of your main questions that you're asking yourself. And if you can't, like Professor Kelder said, what arguments can you make? You also want to think about what the counter arguments are going to be. So you can say, well, I can guarantee you this is going to be brought up from the other side, and this is how we knock it down. Don't forget about that aspect. So you've got 20 minutes, group yourselves up, and start brainstorming. I'm going to be strict on time, so 20 minutes and go. If you need anything from me, let me know.
It's 1:25, we got to 1:45.
Yep. Okay. So we have a couple of minutes. I want to be able to open this up a little bit so that if you have questions or comments for other groups, or if you would like to further your argument based on what you heard of someone else's argument, I want you to be able to do that. But I do want to take like 2 minutes and just kind of give an overall kind of question type of thing. So I'm going to go roughly from group to group. But the first question that I have would go both to group 1 and 2, because you both made the point, group 1 much more so than group 2, that this is bigger than litigation. And the question I would pose to you is, what type of policy initiative could you think of that would have effects bigger than what Brown had on education as far as segregation? So if you're saying that this is something that is much more of a policy issue, which I agree with all of you, it is a policy issue, but something, especially from you guys, is that the policy issues aren't working. The policy solutions aren't working. And this is why people are more and more turning to the courts, because the policy issues that people have come up with, and there have been some pretty creative ones, have not been working. And so they look at things like Brown and say, it didn't work all the way, but it was a really good start. As you guys said, it was a really good first step. So should we take more steps in that direction? So that would be my general question, kind of that goes to all of you, starting mostly with group 1 and expanding throughout the rest of the groups, is there a social implementation that you can think of, social policy implementation, that would actually make things something bigger than Brown? Because everybody knows what Brown v. Board is. Let's see. Group 2, I just wanted to kind of put out there that I like that you decided that you would have 3 suspect classes that would be involved, and that you said these are going to be suspect classes. And based on race, that's already, they've already said in so many Supreme Court cases that's a suspect class. It's part of strict scrutiny. But I want you to think about how you would prove, how would you make it so that class-based distinctions and ability-based distinctions would be a suspect class? What type of information would you need to make that allegation? Let's see. And then the third group, you said that it wouldn't be a suspect class. So I'm wondering what your thoughts would be on how you can have a suspect class that would be racially based, but when that flows into other classes such as wealth or ability, things like that, how that doesn't permeate into it, which the courts agree with you. So I'm wondering where that argument is, where it stops. Can you just say, as you guys also said, your questions would have to be narrowly tailored, that you couldn't just give a test that was bluntly racial, because that wouldn't work either. So where do you put that stopping line on your suspect class if you can't say that it's going to be just all in all a racial issue? And then group 4, and this is where I'll wrap up, and if you guys have anything to say, I would love to hear from you. You guys got stuck on the answer, which has been baffling education people for ages. And there are so many different things to think about. You guys are thinking about the structure of the schools and what would work. But when Brown was decided, the Supreme Court didn't say, well, this is how you should really desegregate your schools. They said, we're leaving it up to the school districts. You guys figure it out, but you have to make sure it happens. something that I wouldn't expect you to know. Comparative cases. Italy, as far as their disability studies, same type of idea as Brown was for race. They had not a court decision, but a social policy decision that, you know what, we're going to do complete integration of kids with disabilities, no questions asked, make it happen. And they literally made the change overnight. They didn't say, like Brown, with all deliberate speed. They said, it's happening tomorrow. Figure it out. And it was a rough change, but they made it work. And now they have one of the most accessible educational systems in the world. So the question is, do you really have to come up with a solution? Or can you do something like we're saying with Brown and say, you know what, we're gonna leave it to you guys to figure out your social policy aspect of it. We'll do oversight, and we're just saying you have to make it happen. So those are my questions and my thoughts. We have about 6 or 7 minutes.
Can we hear from the most senior counsel in the room?
Absolutely.
You know me, I'm the guy that falls asleep at the meetings. Ordinarily, in a situation like this, I've talked a little bit about law reform litigation. You know, don't jump off the diving board unless you know how deep the water is, right? So I'd be inclined here to try the political approach. But I'm not quite sure about that. But I don't have time for all of that. Is there a constitutional right to education? No, let me ask it a different way. Is there a constitutional right to be provided with an opportunity for a decent education, free from the deleterious effects of racial discrimination, unequal funding, and the like? Right? That's the question. What do we cite when people say, is there a right to education, fundamental right? What does everybody say? Rodriguez, right? I had you read it for today. Did you read it closely? I read it for the 15th time, and I read it as closely as I could, because I was trying to see, just, is there any wiggle room here? When was it decided? 1973. Did you catch all that language in there? It's not our province to announce substantive constitutional rights. And I thought, same-sex marriage, right? Right? We don't want to intrude, right? 73, Roe wasn't even decided yet, right? They talk in terms of activism, recognizing fundamental rights. I thought of that, and I read it closely, and I saw there was this language in the opinion where the court says on page 997 of your textbook, a sufficient answer, right at the bottom, sufficient answer to appellee's argument is that at least where wealth is involved, the Equal Protection Clause does not require absolute equality or precisely equal advantages. Texas asserts that the minimum foundation program provides an adequate education for all children in the state. No proof was offered at trial persuasively discrediting or refuting the state's assertion. I bring this litigation arguing fundamental right, my concept of opportunity for free education. We're going to have all that data. We're going to have all those studies, just like Brown versus the Board of Education. We're going to have all those studies that show the deleterious effects on everybody's education and promise for life if you have to have education which is unfunded, substandard, in a segregated school, right? What else do they say? On the next page, 998. However described, it is clear that the appellee suit asked this court to extend its most exacting scrutiny to review a system that allegedly discriminates against a large, diverse, and amorphous class. Unified only, the only thing they have in common, by the common factor of residents in districts that happen to have taxable wealth, less taxable wealth than other districts. That's not us. That's not our case. What else unifies ours? We've got a system of education in place that it's the product of prior, intentional, de jure discrimination. It's the product, let's be honest, why do we have these bastions right now? These areas in our central cities that are resegregated. Why do we have that? Because of unemployment, because of crime policies, because of housing policies. And what do they all have in common? There's discrimination, replete, ongoing, in every facet. We don't have a group of people here, the kids in our district, that are unified only, like in Rodriguez, by the fact that they come from different tax districts that have more or less wealth. We've got a unification here that cries out for recognition, that there's a need to recognize a fundamental right here to provide ample protection. And then if you look at the dissenting opinions, I mean, about what we're doing is creating a permanent underclass. What we're doing here is making it harmful to our nation in terms of being able to promote civic responsibility, civic trust. What did Orfield say? Polarization? That this resegregation has bred polarization? Do we see that today? I mean, my special area is criminal procedure. Boy, do I see polarization today. And you all see it. Ferguson, Trayvon Martin, Garner, the whole bit. Is segregation, I mean, is desegregation, is a recognition of a fundamental right to education a panacea that's going to, like, wave a magic wand and end all of that? No. But it's a way to begin. Now, the thing I didn't like about affirmative litigation here is I got to say, what's the remedy? What's the remedy? And Susan just gave it to me. Get it done. See, I don't have to do all of the political lifting, right? I don't have to go to the school board. I don't have to go to the Catholic school and say, do you have capacity? Can you open up some of those schools you just closed? Would you like to take schools on vouchers? I don't have to go begging Governor Cuomo and his aides. Can you give us more money? Can you take some of that money from Say Yes to Education? Can you put it into a voucher program? Oh, and can we use vouchers for the charter schools? Oh, but more importantly, can we have an agreement, a contract that the charter school will diversify? In other words, they'll take into account race when they make admissions decisions. Oh my God, that's going to put us in parents' territory. Are there more narrow alternatives? I don't mind being on the defensive on all that, if I could get it done, if I could get all the powers to be to come together and agree on all these changes. I think it could be done. I think smart people in a room could come up with attendance policies, assignments, taking racially conscious measures into account, deal with those charter schools and make them diverse. The magnet schools as well, regional magnet schools. You don't need busing for that. Let's have a regional magnet school. Do the same thing. Have agreements, and it would be funded. So we'd have socioeconomic parity as well as racial parity. We could get it done. It's going to take a hell of an effort, and it's going to mean people are going to have to get involved, roll up their sleeves. Do I think that's possible? I don't know. Which is why I'm eyeing the litigation approach right now, because I read Rodriguez not as a door closing. Did you read the last paragraph? After all is said and done, they say it would be premature right now, because we're not experts in educational policy. My litigation would make them, force them to become experts in educational policy. And I'd say it's no longer premature, folks. It's now 2015. It's 32 years later. It's long overdue. Not premature, long overdue. So I don't read Rodriguez as closing the door. When I almost had an epiphany. Because I'm thinking, geez, every time I've heard Rodriguez discussed, it's always so depressing. It's done. It's done. And I'm going to go back and do some research on my own to see if anybody's ever tried to make the argument. How often has the argument been shot down summarily because of Rodriguez in the last 20 years? Boy, I tell you, I wouldn't be completely surprised to see not much, because the argument's not been made. Because the argument's not been made. We've taken Rodriguez, we've put our tail between our legs, and we've retreated. Maybe it's time to dust off that same argument in a different context and bring it to the Supreme Court and federal courts today. I haven't decided. Litigation, politics, but I do think it's possible. I do think it's possible.
Some goodies for you
I want to
guys.
thank Susan for doing this for us today.